Good morning and welcome to the South Carolina Public Service Commission. It is May 21st, 2025, approximately 10 a.m. We are here today on docket 2024-336E concerning matters dealing with the South Carolina Energy Freedom Act. First, it appears all commissioners are present in the hearing room. I would like to take this opportunity and especially like to welcome Commissioner David Britt, who is 2 seats over to my left, who was recently elected to represent the 4th Judicial Circuit. We are delighted to have him join us and know he brings a wealth of experience, knowledge, and from what I've seen, energy to share. Welcome.
Thank you, Mr. Chairman.
Ms. Westerhill, if you would, please provide the details of today's oral arguments as we go forward.
Yes, sir. Thank you. And good morning, all commissioners and all those who are present with the commission today. Today, this is the oral arguments in the matter of docket number 2024-336E, which is entitled South Carolina Energy Freedom Act Proceeding Pursuant to South Carolina Code Annotated Section 58-40-20 subsection E, which is the first revisit of the methodology for calculating the value of the energy produced by customer generators. On April 24th, 2025, the clerk of the commission noticed this hearing for oral arguments. The purpose of these oral arguments are to address the following issues. Number one, what is the appropriate scope of the proceeding, including whether the solar choice methodology should be evaluated in this proceeding, given that South Carolina Code Section 58-40-20E states, quote, the value of the energy produced by customer generators must be updated annually and the methodology revisited every 5 years, end quote. 2, whether a full evidentiary hearing should be required in this docket or whether the matter can be determined based on filings. And 3, any other issues that the parties believe the commission should consider related to this particular matter. Mr. Chairman, the docket is in order.
Thank you very much. I'm going to ask the parties now to introduce themselves, but we're going to go a different order. I'm going to start with the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Vote Solar, and Upstate Forever. Mr. Goody.
Good morning, Chair Powers. Thomas Gooding on behalf of the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar. My colleague Kate Mixon is also joining us, but she is virtual today.
All right. Ms. Mixon, you there?
Yes, I am. Good morning.
Good morning. Next, I'd like to Dominion Energy South Carolina.
Good morning, Chair Powers and members of the commission. I'm Chad Burgess. I'm in-house corporate counsel for Dominion Energy South Carolina. And with me today is Michael Anselmo from the law firm of McGuire Woods. He serves as the company's outside counsel, and together we represent the company in this proceeding.
Thank you. Welcome to you both. Duke Energy Carolinas and Progress, LLC.
Good morning, Chair Powers, Vice Chair Williams, members of the commission. Welcome to Commissioner Britt as well. On behalf of Duke Energy Carolinas and Duke Energy Progress, I'm Sam Wellborn. My co-counsel this morning is Ashley Cooper of the law firm Baker Donaldson. He is regrettably caught in traffic and will be coming in on 2 wheels, but he'll be here any moment.
Well, the only thing worse than I-26 is I-95.
Preach. Thank you.
All right. South Carolina Department of Consumer Affairs.
Good morning, Mr. Chairman, members of the commission. Roger Hall on behalf of the department.
Welcome. And last but not least, Office of Regulatory Staff.
Good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. It's a pleasure to be with you today. My name is Chad Torrey with the Office of Regulatory Staff, and I'm joined by Mr. Tom Philopoulos, who is our newly minted ORS attorney.
You got him broken in yet?
I'm trying my best.
Thank you very much. All right. We are going to proceed at this time. And I would think Mr. Gooding goes first. Mr. Gooding, you or Ms. Mixon, since you pretty much requested this, I'll ask that y'all go first.
Mr. Chair, if I may,
Vice Chair.
Before the lawyers get started, I know everyone is ready to go, but in terms of efficiency, at least from me, if all the lawyers would address a simple question, what is to be gained from a full hearing and what is to be lost from a paper process or the simple filing of comments. Thank you, Mr. Chair.
Thank you. That's a very good question. All right, it's all yours.
Thank you, Chair Powers. I will be making our arguments today, and apologies for not being able to be there today in person. Good morning, Commissioners. My name is Kate Mixon, and I represent the South Carolina Coastal Conservation League, Southern Alliance for Clean Energy, Upstate Forever, and Vote Solar in this proceeding. Commissioner Britt, I also want to say congratulations and welcome to you, and I look forward to meeting you in person soon. I'll note, so myself, so I and my clients were also involved in the prior value of solar proceeding and the solar choice tariff dockets, among many other matters at this commission. And so I appreciate the opportunity to try and answer the commission's questions about the appropriate scope of this first revisit of the methodology used to calculate the value of solar produced by customer generators. I will caveat my arguments first by saying that I am an attorney, not a subject matter expert. So I can't try to predict the exact issues that may be raised in this proceeding, but I will do my best to address the questions in the notice of oral arguments, including Commissioner Williams, the question about the value of a full evidentiary hearing versus a proceeding based on the filings. I thought it would be helpful to first start with some background on the existing methodology used to quantify the value of solar, as most recently modified in docket number 2019-182E, and in the lead up to this proceeding. So we have had net metering for solar customers in South Carolina since 2008, but it was first codified into law in 2014 with the passage of Act 236. And just generally speaking, in a net metering program, a utility will essentially allow a customer's meter to run in reverse if the amount of electricity that the customer generates is more than what the customer is consuming. And at the end of the billing period, the customer would only pay for his or her net consumption, meaning the amount of energy consumed minus the amount that was generated. This can take a lot of different forms and structures, as we'll talk about later. But that's kind of the general idea. Act 236 required utilities to offer one-to-one net metering programs, which allowed customers to offset their own usage, but also compensated customers at retail rates for their exports to the grid. And it required the commission open a docket to establish a mechanism for utilities to recover any incremental costs to the utilities as a result of those programs. And so to determine how those costs would be calculated, the commission opened a generic proceeding, and there was a resulting methodology that was approved in order number 2015-194. And that methodology was intended to calculate the net value, meaning the net benefits of DER generation based on a value stack of 11 categories of costs that the utilities would avoid or incur as a result of using that renewable generation from the customer in lieu of other generation sources. And so that includes things like avoided energy losses or line losses, avoided capacity, transmission and distribution capacity, fuel hedge, among other categories that are outlined in that framework. And then under the framework of Act 236, utilities were able to then recover in the annual fuel proceeding the difference between retail rates and the value of solar for the energy generated from customers under that legacy net metering program. And so as the value of solar went up, again, as determined by that methodology, utilities recovered less and vice versa. Subject to a cap of $1 a month for residential customers up to $100 a month for industrial customers. When the Energy Freedom Act passed in 2019, the legislature decided to move the state away from this one-to-one net metering program toward a different structure that was intended to balance customers' ability to save money on their bills by installing solar while still ensuring that they were paying their fair share to maintain the grid. And so for customers that signed up after June 1st, 2021, the law required that the commission approve new solar choice tariffs. And utilities would not be entitled to recovery of those lost revenues for those solar choice customers anymore. Although they could and can still recover costs for legacy net metering customers until full cost recovery is realized. And so in advance of the solar choice proceedings, under Act 62, the commission was required to open a generic docket. And that docket under the statute had two purposes. It was both to investigate and determine the costs and benefits of the current net energy metering program, meaning the legacy one-to-one net metering program. And second, to establish a methodology for calculating the value of energy produced by customer generators. So there's kind of two prongs. And then for that first prong, evaluating the costs and benefits of the legacy program, the legislature set out specifically what the commission should consider in doing so. And that included a number of factors, and there were four, including the aggregate impact of customer generators on the utility's long-run marginal cost of generation, distribution, and transmission, cost of service implications of those customer generators on other customers within the same class, and it set up a kind of separate analysis to evaluate that for analytical purposes only. The direct and indirect economic impact of that program to the state, and then lastly on that list was the value of DER generation according to the methodology that was approved by the commission under the Act 236 program and Order 2015-194. So the commission had the generic docket, and then they issued Order number 2021-569 in the generic docket in August 2021. And that order reaffirmed the general validity of that value stack in the categories within it, although it did make some changes to that methodology, and specifically in terms of how some of those categories would be calculated. One of the findings that the commission made was that the cost of service analysis, which essentially looked at solar customers as a separate class for analytical purposes only, will be helpful in fine-tuning solar choice metering rates and design in future proceedings, but will not itself be determinative. And so when the commission kind of turned after that generic docket to the solar choice dockets that were proposed by each of the utilities, the commission's findings in that generic docket were informative to their evaluation of solar choice tariffs and their program design for each, and in particular, the cost of service analysis findings kind of helped inform the design of those tariffs. As the commission's, but they were not determinative, as the commission's order stated. And there were a lot of distinctions between what was considered in that generic docket and then the subsequent solar choice tariff proceedings. First, the solar choice tariff proceedings were very utility specific. They're based on analyses of each utility's particular costs and particular systems, for instance, when their system peaks were, and how solar customers on that system would interact with and affect the costs to the utility and to other customers. Second, in approving tariff designs, the commission had to balance entirely different considerations and factors than were evaluated in the generic docket. So for solar choice tariffs, the commission had to balance bill savings for solar customers with minimizing cost shift to other customers to the greatest extent practicable. And ultimately, the resulting solar choice tariff structures for Dominion and Duke use time variant rate schedules that ensure solar customers are compensated for and pay for their contribution to or use of the system based on the needs of the system at different times. Those are factors that were not captured in the value stack or the methodology, but that really kind of form the basis of the tariffs themselves. So now kind of turning to the specific questions that the commission posed in its notice of these oral arguments. First, what is the appropriate scope of this proceeding, including whether the solar choice methodology should be evaluated as part of it. And I'll first say, in the statute, there is a distinction between the first generic docket, meaning docket 2019-182E, and the revisiting every 5 years. In that first proceeding, again, looked at two issues, both the costs and benefits of the legacy net metering program, along with the requirements for what that evaluation would entail, and second, the methodology to quantify the value of solar produced. Importantly, the revisit only requires looking at the methodology for valuing the energy produced by customer generators. Under the statute, those other considerations, including looking at the costs and benefits of the legacy program, are not part of that. And so in our view, the purpose and the scope of this proceeding is actually quite simple. It is to reevaluate whether the methodologies used in that net metering value stack are still appropriate. As the legislature required, should be reevaluated every 5 years. We don't believe that this proceeding is the appropriate place to evaluate the solar choice tariffs themselves. Kind of the most fundamental reason is that a change to that value stack wouldn't have any impact on the solar choice tariffs. Again, those two different kind of methods were established using different methodologies, different balancing factors. And again, the tariffs themselves are utility specific, not generic. In terms of how this value stack and the methodology is still relevant. So first, there are still legacy net metering customers, and utilities are entitled to recover costs from those customers under the existing, under the methodology through the fuel clause until all those costs are recovered. And under the Energy Freedom Act, it allows customers who signed up for service prior to June 1st, 2021 to continue to receive service under the legacy net metering program until May 2029. Second, the value of solar is used in some very limited instances in some of the solar choice tariffs. I think most particular, and I'm sure Dominion Energy's attorneys can correct me if I'm wrong, but I believe that under Dominion Energy's solar choice tariff, non-residential customers are credited for net exports at the rate that is established pursuant to the methodology that was established in the 2019 generic docket, and presumably that will be updated here. Lastly, the value of solar methodology can appropriately be used as a high-level evaluation of the benefits of customer-sited solar generation and methodologies to calculate those benefits, which may be informative when considering distributed energy resource programs more broadly. One factor the Commission may consider is that the new energy legislation, House Bill 3309, authorizes utilities to propose distributed energy resource programs that would be evaluated using cost effectiveness testing methodologies. And some of the cost benefit categories under the value of solar value stack may overlap with those used in that context, and so it could be relevant to the design of those programs. In addition, there are some issues that really haven't yet been addressed as part of the existing kind of value stack. Again, under H3309, programs that would, for instance, pair battery storage with solar or pair solar with different load control or energy efficiency measures could be part of a kind of comprehensive program. And one issue that hasn't been considered would be, for instance, whether the value of a kilowatt hour that's produced by a solar customer who also has storage on site may differ, or whether there may be some changes to the methodology used to evaluate the value of solar from that customer versus one who only had solar. Next, I guess, as to whether a full evidentiary hearing would be required in this proceeding. So we do believe that a full evidentiary hearing may be beneficial to the commission. Many of these issues are very technical, and we certainly think that the commission benefited from being able to ask witnesses questions in the last proceeding. But with that being said, it may be possible for the commission here to issue a decision based on the filings. It's just difficult to say until we know what each party's positions are and how far apart that they are, which we wouldn't know until initial testimony or comments were filed. One approach the commission could take would be to allow initial and responsive comments to be filed and to set an initial procedural schedule that allowed for that. And then in responses, allow parties to request a hearing if they thought it was necessary, or after reviewing the filings, the commission could decide to establish testimony deadlines and an evidentiary hearing after that point. The commission's final order here must be issued by August 2026. So the commission certainly has some time to consider this proceeding and could build some flexibility into its procedural schedule here to allow for that. Thank you, and I am happy to answer any questions.
Thank you, Ms. Mixon. We're going to try and break this up as far as maybe have commissioner questions as we go. Does anyone have any questions for Ms. Mixon at this time? And certainly we'll have questions at the end as well. All right, thank you. All right. Next, we're going to Dominion Energy.
Thank you, Chair Powers, members of the commission. Michael Anselmo on behalf of the company. I want to start by saying thank you for letting us present these arguments. I think they're going to be beneficial to the questions that the commission has posed in the notice and here today. This docket was open to discuss the timing of the revisit of the methodology for customer generators under Act 62. There are two methodologies, as Ms. Mixon mentioned, one for NEM customers and one for Solar Choice customers. They're distinct and separate. I think they've been referred to as new and different, the Solar Choice tariffs. And everybody here is in agreement that the commission will comply with the revisiting mandated by Act 62 using this docket for NEM customers. In the forum and in the comment letters, there were two sort of thought processes on how that compliance comes to be. The first was y'all opened the original the docket in 2019. By starting this docket and taking it through its conclusion in 2024, you complied. Another, I think, correct interpretation is also you issued the original order in August 2021. So you have 5 years from that date to issue the order in this revisit for NEM customers. I think either are perfectly acceptable, but I think it's semantics. We're in the docket. You're going to address it and certainly issue an order before August 2026. Now, the company's position in the forum and in its comments is we do not need an evidentiary hearing for NEM methodology. Our letter set forth the numerous orders and dockets in which this methodology has been vetted. It's durable, it's time tested. Heck, it was approved even before Act 236 came into existence. We think comment letters are appropriate because this company, Dominion, I'm not sure, I think Duke as well, but I'll let them speak, are not going to be proposing any changes to its NEM methodology in this docket because they're so time tested and they've suited everybody well. Now, what is the methodology? Just quickly. And Ms. Mixon hit some of this, so I won't do it all. Dominion calculates the 11 components of value in the NEM value stack to help create the NEM incentive and allow DSC to cover net loss revenues. That's reviewed annually in the fuel proceeding, as you all know. Mr. Neely submits testimony every year setting that out. And then payments to customers for excess generation credits that exist for their metering are paid to those customers using DESC's avoided cost PR1 rate. That's reviewed every 2 years in the company's avoided cost proceeding, one of which is currently pending before this commission. So we don't think, I never say never, but we don't see really any significant value that can be gained from a merits hearing when we've all been through the commission and the parties, the NIM methodology for almost 11 years at this point. So, and this is also important as you look to the number of NIM customers that the company currently has on its system. The company has over 800,000 total customers. The NIM 2.0 customers, as of a couple weeks ago, total 9,118, and they only stay on those tariffs until the end of this calendar year. They drop off on New Year's Eve 2025. NIM 3.0, there are even fewer customers. There's 2,438, and they only remain on that tariff until May 31st, 2029. And these numbers decrease pretty frequently. As you'll see, even from the filing of our comments in March, the numbers have already gone down again. So those are, they're decreasing. It doesn't seem to make much sense to revisit and have a merits hearing on the revisit for an ever decreasing number of customers, especially when the methodology has been so time tested and approved. And this will be the last revisit. This came up in the forum that the commission will need to do for NIM customers. The Act 62 moves them off of NIM tariffs as of May 31st, 2029. So there will not be another 5-year revisit for NIM customers. So we can put it all to bed right now, final revisit on comments for efficiency and for the reasons I stated. And then in the notice, the commission has asked specifically whether solar choice methodology should be revisited in this docket. The answer is no, and there's several reasons why. I think they're important to go through. Again, solar choice metering, so the solar choice methodology is different and distinct from the net energy metering methodology. It has to be, because Act 62 removed the company's ability to recover net loss revenues. If they had kept it the same, we probably would have kept the same net energy metering methodology. There wouldn't be solar choice tariffs. It had to be approached differently. And the solar choice methodology's been approved by this commission in Order 2021-391. And here's what it is. It's quite simple. Solar choice customers must take service under rate 5 and the rider to residential rate 5, known as the solar choice rider. So they take service under rate 5. The energy charges and time of use periods are set forth clearly in that tariff. And then any excess generation credits, again, are paid at the avoided cost PR1 rate that is addressed every 2 years in the company's avoided cost proceeding. And as I said, we have one pending right now. You'll see in that docket the PR methodology tariff that explains the methodology used to value energy is set forth in that tariff, and the PR1 sets forth the number associated with that value. And in the notice and in the introduction today, subsection E of 584020 was mentioned as to the sort of, does it apply to the solar choice methodology? The rest of the terms of the statute and other statutory constructs make clear it does not. That is a net energy metering specific requirement. First, the methodology in E, in the NIM methodology, required an annual review in our fuel proceeding of the value of energy. That is the NIM value stack that everybody knows and discusses all the time for use for the incentive of the net loss revenues. Act 62, as I said, removed that requirement, so it obviously cannot apply to an avoided cost docket and the solar choice tariffs. And then it says you have to revisit 5 years. Now, Act 62 later on allows the commission to sort of lock in the solar choice methodology and energy value for a defined period of time that can exceed 5 years. And this commission did that by setting a 10-year, what I call lock-in period in that order, that subsection H that allows it. It would be illogical to say that you could lock in something for 10 years, but then halfway through confuse the customer, have a revisit where it could change, and defeat the benefit of the 10-year lock-in period. And then lastly, I've mentioned this already, the General Assembly required requires the company to come in every 2 years to have its avoided cost methodologies and energy values revisited by the commission. You wouldn't have a 2-year check-in on avoided cost if the General Assembly thought you had to come in every 5 years to get a check-in on the calculations for the solar choice tariffs and rider. So it doesn't apply. E is specific to NEM, as you can see from the language of the 2 parts of E, and for the reasons I just mentioned today. And just to close, it sounds like there is now lots of agreement between us and the other parties in regards to the scope of the proceeding. That appears to be different from the comment letters, but I think what I've said adequately captures the agreement. NEM, revisit here through comments. Solar choice stuff is done every 2 years and avoided cost. That's all I have, and happy to answer questions now or at the end.
Thank you, Mr. Anselmo. Any questions at this point in time, or do we want to wait till the end?
Chair Powers?
Commissioner Williams?
Thank you. One simple one. Mr. Anselmo, you reference PR regularly. What does that stand for?
That's the name of the actual tariff that's filed in the avoided cost proceeding. It is the avoided cost -PR-1, and that's just want to make clear that is the tariff that is used to value the energy that we're going to credit for net energy meter.
This will tell you how my brain works, but what does PR stand for?
I wish I actually knew the answer to that question. I should have known that by now, but I've never actually thought to ask. I'll shoot a text, and if we get the answer, I'll let you know. But
I'll remember it better that way.
All right,
Thank
thanks.
you.
Thank you, Commissioner Williams. Excuse me. We're going to move to Duke Energy Carolinas LLC and Duke Energy Progress LLC. And welcome, Mr. Cooper.
Sorry, let me try that again. Good morning, Commissioners. Ashley Cooper on behalf of Duke Energy. Thank you very much for your time this morning. Good to be with you. There were a couple of minutes this morning where I was hoping I was going to be with you. I had a little bit of traffic on the way up here and some construction. I have a handout. I don't plan to go through this handout. It's just some background information. Some of it's already been covered by both counsel, but just thought this might be a quick reference for you and your staff and save people a little bit of time and headache. Should I hand it? Hand it up here.
Is any objection from any party as this handout? Hearing none, we'll accept it.
And I'll try to be brief and not revisit a number of arguments that have been made in common. I just thought it'd be helpful to kind of walk through at a high level what's happened that sets the tone and context for this proceeding in the scope and how we can efficiently address it. Let's see. Okay. If everybody can see that okay or not. So as you've heard, if you look, Act 60, in 2015, there was Commission Order 2015-194, and that established the legacy NEM programs. And that was a program that was set up to encourage the adoption of rooftop solar. I think we're all in agreement there. Act 62 came in and continued and addressed rooftop solar, but it addressed it in a careful way. It distinguished the legacy NEM program, the program that was adopted to facilitate the adoption of rooftop solar, from a new program called Solar Choice. Solar Choice was to continue to allow people to adopt rooftop solar, but to more accurately reflect the cost and benefits of what those self-generators provide to the system, while also not in any way hindering them and allowing them to benefit when they consume the energy they purchase. So Act 62 set up two very separate frameworks for these. Act 62 also said there will be a methodology for legacy NEM, and it said separately in Act 62 there'll be a methodology for solar choice. So what did the commission do? The commission set up a generic docket where it revisited legacy NEM. And in that, it confirmed the legacy NEM methodology. It separately came into solar choice and said we're adopting a new methodology which will be referred to as the avoided cost methodology. And so you see that the commission, much like the General Assembly, kept these two programs separate, kept these two programs, the analysis and consideration, separate, because it reflects these two programs have different purposes, right? And they're separate. And it's very, and I think what's really critical is because, and the reason why I'm stressing this is where you have one that's, the focus is, let's have a program that encourages people to adopt rooftop solar. That's a very different purpose than a program that says, hey, let's allow people to do it and have these programs, but let's be careful and make sure that the costs equal the benefits, right? Very different. So in one, legacy, we said, hey, exports will be valued at retail costs, 1 for 1. And we know that that's maybe more than the energy is worth, and we'll call that the NEM incentive, right? Whereas when you came over to solar choice, they said, hey, let's look at a more sophisticated analysis using incremental and marginal cost analysis. I'm looking, you were the chair then, and so I remember that long hearing, so I'm smiling at Commissioner Williams. And let's have these programs be more tailored to make sure that the cost equal the benefits. So that's why I've been very clear about the purposes of the two and why Act 62 treated them differently and the commission did. And so, as you'll see, kind of hit these so when we say the NEM methodologies, what are we talking about? The NEM methodology in the Legacy NEM program, it's an 11-factor methodology that's used in fuel to determine the NEM incentive. That's that delta. That's that amount that, hey, you're getting above kind of the benefit we're getting to the system. In Solar Choice, you adopted for the first time the avoided export methodology, which is paid to customers. And from that order, it says, as for the requirement found in SC Code 584029F, the parties were generally in agreement. The Solar Choice tariffs comply with the statute. The avoided cost export credit is consistent with Act 62's call to create with the, and listen to this, I want to say this carefully, consistent with Act 62's call to create a methodology that compensates customer generators for the benefits provided by their exports to the power system. So that reflects what, kind of what I've been leading up to. Finally, just in the commission holdings, I would direct you to a couple of points. In the generic docket, the commission reviewed the Act 236 methodology and held, accordingly, it's appropriate to continue to use the valuation categories approved in order number 2015-194, which is the original order that adopted Legacy NEM, with some modifications to calculate methodologies and new standards to populate particular value categories. Then when you come over to Solar Choice, the commission held, as for export credit, the shift away from full retail credits for exports is appropriate. As described by the ORS, valuing these exports at the company's most recently approved avoided cost rates ensures that this value paid to these customer generators accurately reflects the benefits provided to the overall system. Given that the new export methodology is tied to avoided costs, the commission agrees with the companies that they are appropriate for collection through the annual fuel proceeding. So again, I'll move on. I think the parties have been pretty consistent to date now on, and I think I heard Ms. Mixon, she acknowledged there are differences between the legacy program, the current program. She acknowledged, I believe, there are different purposes between the two. So turning to the commission's questions, what do we do now? What do we go from here? Act 62 says a revisit of the methodology. And the word revisit not only is in the commission's directive, but it's in Act 62. I think that's an important word. That's not saying develop a methodology every 5 years. It's saying revisit it. Just make sure this methodology still works. And so that's, as Mr. Anselmo said, it's a methodology that's been in place for years now. It's a methodology that was designed for an older program that's going to be phasing out. And so this is an opportunity to, quote unquote, revisit it. We will comply with that and comply with the statute's requirement by doing what the commission's doing now, which is setting up a proposal just to consider anything new before this program wraps up. Therefore, while Duke Energy is happy to participate in a full evidentiary hearing, we do not believe that's the most effective use of the commission's resources in our legal budget and resources, and it doesn't promote any sort of judicial economy or efficiency. We feel like this could best be addressed through a paper comments that are filed with the commission. We do think it is important to continue to do what the commission has done and Act 62 has done, which is to say let's keep the two methodologies separate because we feel like blending them could cause unnecessary confusion. And there's also no risk that because they're so different in purpose, that by considering them differently, you don't have a risk of, well, maybe we got some information here that would be relevant here. I mean, you're talking about something that's completely different. The rate tools that are set up in Solar Choice are much more sophisticated, more modern, more complex. So there's nothing really that we're going to lose. And if there's something that does come out of this paper review, certainly we can bring that forward at a future time. I'll stop there. I think this has been covered. I think there's, as Mr. Anselmo said, I think there's really all the parties may have changed a little bit from the filed comments to acknowledge the scope. So, and continuing the effort to allow for administrative efficiency and economy, I'll stop. Thank you for your time.
Thank you, Mr. Cooper. Is there any immediate questions for Mr. Cooper?
Chair
Mr. Chairman,
Powers.
Commissioner Williams.
Thank you. Mr. Cooper, and really this question could be to others. You referenced 2021 569, which was the initial visit to the NEM methodology following the original, the post Act 62 NEM. Is that correct?
That's correct.
What I have from that order is the beginning, the framework, the introduction that the commission makes in making that order, and it reflects NEM and future Act 62 solar choice metering programs. So the commission at that point was looking at the two together. Walk me through, again, perhaps, although I've heard how, from an order perspective, how are they separate?
Well, I'd say respectfully, let me back up, Commissioner, if you don't mind. I think if you look in the way that Act 62 is organized, right, Act 62 starts with legacy NEM, and it talks about the requirements of the commission. It talks about a methodology, and it lists all those, and it's pretty careful. Mm-hmm. It's not until you get to F that Act 62 looks at solar choice and then talks about the requirements of solar choice in a program there, and separately states a methodology. So I think the generic docket, I agree with you that the beginning of the generic docket and the generic order that you reference, there are some, I think the commission rightly set forth the stage. We're going to look at the legacy program in the context of how it works, what is its purpose today, and how do we use that to inform us about any, or if at all. And I think that was a real question, not that, hey, build off of this. It was truly a question of, is there something to inform us for use in later programs? And so that was the context of the generic methodology. So there was, for example, a question of, is there an economic impact? Mm-hmm. Is there something then about that we should consider and take into programs going forward? But in terms of the more specific questions, like the NEM methodology, the one-for-one retail rates, calculating the incentive, how that flowed through fuel, That generic order was very limited and very specific in its scope, and I think treated the two very differently. I hope that answers your question. Sorry.
Thank you, Commissioner Williams.
Thank you.
Commissioner Bells,
Thank you.
is your mic on, Mr. Cooper?
Yes, Commissioner. I'll talk louder. Sorry, Mr. Chair.
Thank you.
Good morning, Mr. Cooper.
Good morning.
And, if anybody else wants to jump in on this, I reckon, I just think it might be a little helpful if we kind of talk about the different programs if we could. So Act 236 brought in NEM 1. Is
Yes.
that correct?
That's correct.
And when was that effective? Do you recall?
I believe it was at least well. I have it in the
What
fact
you gave
sheet that
us?
it's in the fact sheet that I handed out, and I gave everybody a copy, but didn't keep one myself. Hang on one moment.
Is that, well, that was basically
But I believe it's
order
2015. That's
That
right,
was order
2015.
2015-194.
That's
okay.
right. It's 2015.
And that order, and by statute, customers that have signed up under NEM 1.0 they have that program until 2029.
That's correct.
Whatever date it is. I think it's May 31st,
That's
2029.
correct.
All right. So what is considered NEM 2.0?
Well, I would think that I would think that 2.0
Or-
there may have been
Or is
iter-
2.0 Act 236 and 1.0
That's
was
right. So
1.0
that's
was
right.
that started before Act
That's
236
And then you
passed?
had 236. And the reason why I was kind of holding for a second was, I believe there was somewhat intentional that with Act 62, there wasn't a 3.0, it was a solar choice,
okay.
because to really make that distinction very clear.
So the ones that came on before Act 236, how were they treated? Were they grandfathered in, do you recall? And if somebody else knows, you might want to let me know. But
Let's see.
I'm just trying to get a lay of the land, the history, so to speak.
Yes, and Commissioner, I'll have to follow up with you on that as to the distinction between the two. I mean,
Okay.
I know that the 2015 resulted in a settlement among all parties,
Right.
and there was an agreement. The Commission approved that. I'm trying to figure out.
But okay, and I'm sorry to interrupt, but those customers are off of that program in 2024, and if they want to continue, they will roll over to whatever tariffs are available at that time. Is that correct?
That's correct.
Okay, so then we get Act 62, and we've got what would it be called before we get to solar choice? We get the generic docket that came about with order 2021-569.
That's right.
Okay, and that is valid until when? Customers that may take up under that.
So that has two components. That was just an evaluation of, well, I guess under that specific order, you're right. That would be the continuing legacy NEM, and that's to 2029. Obviously, with the Duke program, customers can move over to solar choice whenever they want, but there is a guarantee to have it until
2029.
Right.
Okay. And so after that, solar choice came about. We had solar choice hearings for Duke companies and then for Dominion companies. I'm not sure of the order. And those orders had to be out like May 31st of what year?
2020.
21?
I think it was, I'll give it to you right here.
21, wasn't it? When is solar choice? May 31st to 21, I believe.
That's right.
Okay. So anybody that signed up for service or solar or with solar beginning June 1 of 21 would be solar choice customers. But those that signed up prior to that could still remain.
That's correct.
And so under solar choice, it's valid for 10 years.
10 years.
Or if it's rolled over or subsequently done, however it's done. So those are the buckets that we're looking at.
That's right.
So because you've mentioned, and I think Mr. Anselmo did too, that we've got dwindling numbers of customers under these legacy programs, the NEM 2.0. And I think Mr. Anselmo called it NEM 3.0. Am I correct on that?
Yes.
So can I just ask you what you meant by this 3.0?
Sure, and this actually relates to an earlier question
I apologize for interrupting you, Mr.
about the order. There were original NEM customers that existed before Act 236 framework. I mean,
Right.
guess the 1.0 people, right? At the time Act 236 passed, those customers migrated to 2.0 customers. Okay. And then with the passage of Act 62, there is a NEM.30 category of customers resulting from that initial order that y'all issued.
All right.
And so for
But we will not have any more customers going under the NEM orders.
That
2.0 or 3.0 or 1.0,
That's
whatever
correct.
the number, Act 236, and then the subsequent, whatever it was under Act 62 that replaced that. We will not have any more customers on those programs.
That's correct. The dates.
They would go under Solar Choice, or depending on when those come up, whatever tariff is approved for the utilities at the time somebody may sign up.
That's correct. The timing on when the 2.0 ends is this year, this calendar year.
12/31/25.
And then for the NEM 3.0, the 2,438 I mentioned is May 31st, 2029. In essence, the drop dead date is the May 31st, 2029. And at that time, those customers would have the ability to migrate over to Solar Choice or any other rate for which they qualify if they no longer own a meter.
I hope I didn't muddy the water for anybody else, but you clarified it for me. I thank you, gentlemen. Thank you.
No, that's perfect. And the risk of, I think it's semantics, whether you call it 3.0 or 2.0, it was an extension. I mean, it's still a legacy.
Well, I just remember the term Act 236 2.0 being thrown around. I don't ever remember 236 3.0 being thrown around.
There wasn't a 236, I think, without putting words in Mr. Anselmo's mouth. I think what Mr. Anselmo's saying is that he's distinguishing.
It was just NEM.
I think he's saying that, hey, under Act 62, you said you can continue NEM for a little bit longer for customers who sign up before a certain date. I think he's calling that 3.0, but it's not a different program, and so that's why you could call it 2.0, you could call it 2.0, 3.0 or 2.0 extended, but you're thinking about it either way. You're thinking about the correct way, or at least the way I'm thinking about it.
That's correct. We categorize them based on timing of when things happened. So.
But there wasn't some sort of substantive difference.
And there's no substantive difference. And the availability section of each tariff explains the timing in which you're eligible for that tariff.
It explains the availability and the end date, doesn't it? Yeah.
That is correct.
Okay. Thank you. Thank you, gentlemen.
And just for clarity and for the record, I think, Commissioner Belser, when you first mentioned the end of one of these programs, you said 2024 instead of 2025.
Thank you for clarifying.
Okay. Chair Powers. Commissioner Caston. I'm sorry, Commissioner Thomas first.
Thank you. Appreciate it. Two questions. One, your slides that you put up. Two slides. Can you make those available to us?
Yes, Commissioner. I have copies for those for the commission as well. I'll provide those. Thank you.
Thank you. And
unless there's an objection from any party. Okay, thank you. No objection.
And by chance, do you have the numbers of customers that remain for Duke in the?
Yes, Commissioner. It's less than 9. I'm looking at Mr. Welborn. It's less than 9,000.
All right. Thank you. That's all I have.
Thank you, Commissioner Thomas. Commissioner Caston.
Can I? Commissioner Caston, would you mind if I followed up?
I do not know.
So, Mr. Cooper, you mentioned 9,000. Can you break those down for us in terms of who's rolling off at the end of 2025 and who is still on the system from 2025 to 2029?
We don't have it, Commissioner, separated like that.
Okay. Can you provide it? in a comment after this?
I'm happy to look into it, and if we can, we will provide it. We'll provide a response either way, but hopefully we can provide what you're looking for.
Thank you.
Commissioner Caston?
Thank you, and glad you made it, Mr. Cooper.
Thank you, Commissioner. I had to laugh. I just got my wife taught me into one of these devices that measures your heart rate and all those things. And it's like my third day. And I'm very thankful for HIPAA and other medical privacy measures right now. But go ahead.
Well, the world would have kept turning whether you made it or not.
Well, I didn't want Mr. Welburn to know that. That was a big problem. I was afraid he would do a much better job than me. So that was my problem, Commissioner.
My heart rate was also going up, Mr. Commissioner.
He stalled appropriately for you.
Thank you.
I guess in a big picture view, what I'm trying to understand, and I'll probably ask everybody, relative to, thinking back to the letters that each company wrote, also including ORS, relative to 584020, is Duke of the opinion, is it the Duke company's position that 584020, that B through E, does that apply to only NEM, legacy NEM?
That's correct.
And F through H applies to
Solar Choice.
Solar Choice?
That's correct, Commissioner.
Is that Dominion's opinion?
I would categorize it as better than opinion. I believe it's the correct statutory interpretation.
I'll take that as that's
yes,
your opinion.
it is a yes.
Okay. Ms. Mixon, are you still on?
Yes, I am. Thank you, Commissioner Caston. So I just briefly wanted to kind of clarify. So our comments did not say that the revisit here necessarily implicated the Solar Choice tariffs themselves, and that was not our intent. Our view is simply that this methodology would be relevant to all customer generators, which would include Solar Choice customers. That doesn't mean that it wouldn't be used in different ways. And for certain types of customers more than others, for those customers taking service under different tariffs. And so, briefly, our concern in cabining this methodology specifically to the legacy net metering customers are threefold. One, we don't think that's what the law says. And so in 584020E, it says the commission's evaluating the value of solar produced by customer generators, not just the value of solar produced by customer generators under that legacy program. We are in total agreement, though, that the use of this methodology to inform cost recovery to the utilities through the fuel clause is limited to legacy net metering customers. Second, there was some discussion around the fuel proceedings, and I would say that in our view, those proceedings simply update the assumptions used to calculate the numbers used for each of those 11 components, but those are not where the underlying methodology is evaluated. And the commission has agreed with that. As an example, in Dominion's 2021 fuel proceeding, our clients submitted expert testimony critiquing Dominion's methods to calculate several components of the value stack. And in the commission's final order, you rejected his proposal, or expert's proposal, finding that much of that analysis would be more appropriate in the methodology proceeding. Lastly, as I mentioned, again, we don't see this as this docket that it would necessarily implicate the tariffs, but as we stated, the way that there could be relevance is that it could affect the kind of calculation of the costs and benefits for distributed energy resource programs moving forward. And so let's say a utility were to propose such a program under the terms of the new statute, and the costs and benefits were calculated using a particular avoided T&D value for solar that was produced. where would that number in the underlying methodology used to calculate it get evaluated, if not in kind of the kind of every 5-year revisit. And so that's our position on this, is that E is kind of distinct, but again, that the methodology itself would be kind of used either for at a much higher level, kind of a more of an informative level for solar choice customers, and for kind of potential future DER programs, whereas it's very used in a very concrete way for cost recovery for customers under the legacy net metering program.
And if I may ask you this too, since you're all queued up, I think in comments by, say, CCL, you talk about the I think complexities and technical aspects of this type case. But hearing earlier comments, your presentation earlier, is it fair for me to assume that, say, so CCL, you do not see or have any due process concerns whether there's a hearing or not a hearing?
No, I don't think that there would be due process concerns. Again, our view that an evidentiary hearing may be beneficial to the commission is more for kind of the benefit of the commission in having the ability to ask questions of witnesses about their proposals for any changes to the methodology. That would be how we thought it might be beneficial.
And I guess another question I'll ask you three, what it's worth, is you mentioned the revisit, and I agree it says that. Can the commission effectively revisit without a hearing?
I believe so. I mean, I think that the commission does an effective job with receiving comments from the parties, and these comments are often, it gives people the parties time to develop it. I think written comments have the benefit of everybody has a chance to review them internally and have a lot of thorough input from various parts of the company. So I feel like the comments that are submitted to the commission in a paper proceeding are typically well thought out, very thorough, and the commission at times has asked specific questions. Those questions are all answered. So I think that the commission's history and track record have shown, Commissioner, respectfully, since you asked my opinion, I think it's shown that it can be handled that way very effectively.
Mr. Anselmo, well,
ditto. We agree. And Commissioner Casson, to follow up on one of your other questions, NEM is not relevant in any way to solar choice. The company does not use it in the methodology. It is not used in setting the rate PR1, which stands for PERPA rate. I learned that today as well. Thank you. And that rate is what is used to pay the customers, right? It's just simply not used. And also, as any argument that you will see NEM associated costs in future DER recovery in the fuel case is incorrect. Once these customers run off, there will be no NEM component on the DER. You've seen the chart from Company Witness Rooks that has all the components that go into it. Guess what will be missing after these customers roll off NEM? The NEM component. It simply doesn't exist after they roll off. Now, it rolls off mid-year, so in 2030, you might see 6 months of it, but by 2031, it's zero. It's irrelevant.
All righty. Ms. Mixon, any comments relative to that revisit item?
Yes, again, as I stated in my initial argument, I think the one question would be, I guess an issue is that it would be difficult to say how helpful that an evidentiary hearing may or may not be until we know what parties' positions are. I certainly don't know what our position will be on potential changes to the methodology, which is why I suggested that one approach would be to, set an initial procedural schedule with, initial comments and then responsive comments, and then address the need for an evidentiary hearing if required after that point.
Okay, thank you. And Mr. Hall and Mr. Torrey, you've not provided anything yet, but there's strong possibility I'll probably ask you these same two questions. So I assume you paid attention.
Yes, sir, absolutely.
All right, thank you. Thank you. One final thing, while you're there, Mr. Cooper, relative to, I guess, the DEP solar choice requirement for the 5-year export methodology. Why do you think that's there? Help me understand that.
In the generic, or why was there a request to revisit every 5 years? I think probably because you have like the avoided cost methodology in solar choice is that's part of this avoided cost docket that gets revisited every 2 years. The NEM incentive is more just something that's in place, and I let me be clear, Commissioner. I'm working with you to give you an answer. I want to say very clearly, I don't know exactly what the State House was thinking, the legislature was thinking when they put it in. I suspect a reasonable interpretation, one answer among others, is that because you had this NEM incentive that was a little bit different, that might have been the reason for saying, hey, let's revisit this every 5 years so we know and we can monitor it, and just kind of a prudence measure.
All right, I'll stop here and let's see what others have to say. Thank you.
Thank you, Commissioner.
Chair Powers?
Commissioner Williams.
Thank you. This question really is a question for everyone, and it is sparked in part by something that Ms. Mixon has said, but I gather that you're all in agreement that we could move forward with comments in this docket. How do we make a decision based on comments versus testimony?
Well, I think, respectfully, Commissioner, I think a couple of thoughts would be, given the fact that this is an established methodology, it's one that's been in place for a while, and it's one that's being phased out, the idea of there being new developments, new market trends, things where you'd want to ask a witness or an expert and hear from them, or whether you'd have competing competing testimony about the relevance of new market information or new trends or something like that, and you'd really want to be able to question both. I think I would be evaluating. I think the risk is lower here because you have an existing methodology. You're not talking about something that's, the trend is more towards solar choice, away from this, away from one-to-one retail values. So I think just at the start, the risk is very low. You would need to have witnesses present for questioning. Then I think it's just a matter of looking, as you've heard today, the scope and what originally filed comments might have sounded like there was a divergence of opinion, but really there's been, the parties have come a lot closer together, and what they're acknowledging is needed, what the purposes of this is for. So I think when you see the written comments, that will also be instructive as to whether should there be follow-up. But that would be my initial take as to the adequacy of paper and how you kind of evaluate whether something else would be needed.
Let me clarify before anybody else comments and let you respond to this. I didn't mean to suggest that I was asking about a hearing and the ability to cross-examine. It was more having sworn testimony that we could review as opposed to that we could review as opposed to, as someone said an hour or so ago, being lawyers and you're talking about legal arguments versus sworn testimony that we could review. So just asking about the difference between comments versus sworn testimony.
Okay, thank you very much. That's helpful. And Obviously, I think that what we've had today was an appropriate use of legal arguments to know what was required out of the statute, what was required out of the orders that followed. I think where you're getting into a revisit of a methodology, the lawyers, no offense to my colleagues, the lawyers are not needed with that. That would be subject matters experts that would provide that. I think whether that's provided in the format of comments or written testimony is a little bit of form over substance. I mean, if you think about it like a data response, the parties put down who was responsible for the data response. I mean, you could ask to see who contributed or something like that if that would help. But I think that with something like this, with the questions that are presented, it would be in the form of written comments submitted from subject matter experts to give you this update.
Does anybody else want to jump in on that question?
Happy to help. Ashley said this, or Mr. Cooper said this initially. This is something that has already been approved, the NEM methodology. It's a revisit. It's not a restart. It's nothing of that nature. It's not an initial determination by the commission on the subject. Frequently, y'all do use comments. For instance, DSM dockets can be done by comment. And accounting orders, I'm thinking off the top of my head, pension riders, things of that nature where maybe a lawyer submits the letter saying, here is the company's position. We have ethical obligations to represent our client's position. But to the extent there's any question whether you need sworn testimony, we can always have a verification filed with the comment letter. And as we do in dockets involving testimony, which transmit that into evidentiary.
Thank you. That's helpful. Anyone else?
Hi. Yeah, I would just add, I agree with Mr. Anselmo. I think what it boils down to is just a different type of evidentiary record, right? You have to decide on the evidence before you. In a comment letter case, it's the written comments, and a pre-filed testimony, it's a combination of the testimony and the live hearing. So that's essentially up to the commission, but the laws and regulations do allow for that, for efficiency and for other reasons. So to me, what it boils down to is just a different type of evidentiary record.
Okay. Thank you. Anyone else? Thank you very much.
And Commissioner, I'm going to take my seat, but just real quick and follow up to a question you asked. We're still going to update you on the customers that will roll off at the different time periods, but I do have that later this year, of the less than 9,000 that I mentioned, 6,100 will roll off at the end of this year. So,
thank you.
Thank you, Commissioner Williams. Thank you, Mr. Cooper. We're going to give Department of Consumer Affairs and ORS a few minutes to get their thoughts together, because I know you've kind of been left out of this conversation. We're going to take a little short break and come back at 11:25. We are in recess. Welcome. We are back on the record on docket number 2024-336-E. We have heard from 3 of the parties, and we are now turning to South Carolina Department of Consumer Affairs. Mr. Hall.
Good morning, Mr. Chairman. I appreciate the opportunity. The department did intervene in this matter just due to the potential for impacts on residential customers, but we have not filed any comments related to this issue, and I don't have anything to add at this time.
Well, thank you very much. Now we turn to ORS. Mr. Torrey, you have the floor.
Thank you, Mr. Chairman, and now I feel like I need to speak even quicker. Again, good morning, Mr. Chair, Mr. Vice Chair, and Commissioners. Chad Torrey on behalf of ORS. You're going to hear, the Commission's going to hear me say a lot of very little things that are novel. You've already heard most of it this morning, but I did want to reiterate ORS's position on these issues. The first being the scope of the proceeding. It's the position of ORS that the scope should be limited to a review of the continued application of the net energy metering methodology or value stack the Commission approved exactly 10 years ago today almost in order number 2015-194 issued March 20th, 2015 to the rates assessed to legacy NEM customers only. Now you've heard discussion about what the reason for that from a statutory perspective, but there's also, I think, a why. And the ultimate outcome of this docket should have no impact on the utility's solar choice NEM customers, and the reason is that solar NEM solar choice does not contemplate any component of 1-1 net metering. The value stack serves as a true-up, whereby the utilities determine whether the solar generation exported to the utilities by customer generators is worth more or less than the 1-to-1 retail rate, resulting in payment of the NEM incentive that Mr. Cooper referenced earlier. Solar Choice NEM, in accordance with the General Assembly's instructions in Act 62, moves away from 1-to-1 and stands separate and apart from legacy NEM. Second issue, and an issue that was of particular importance to the Vice Chair, was the procedural scope of this matter. And it is ORS's position, in agreement with the companies, that the Commission can and should dispose of this matter in a paper-only proceeding. The reasons: one, administrative efficiency. I'm probably not telling you anything you do not already know, but the Commission's hearing calendar for the remainder of 2025 is already quite full. Thus, if the Commission finds comfortable deciding this case on a paper record, it would certainly aid in efficiency. Number two is there are regular proceedings that come before you that are in fact disposed of without an evidentiary hearing. So doing so in this docket would not at all be novel or out of the ordinary. And finally, as Ms. Mixon offered, if after the parties file comments, responsive comments, and or reply comments, the Commission or any party believes an evidentiary hearing is necessary, the decision to hold a hearing could be addressed at that time. Now, ORS's interpretation of the statute, as reflected in the letter that we filed, and I think it's also consistent with the position of all the other parties in this matter, is that your final order in this case must be issued by August 19, 2026. So, we have some time. There's ample time for the hearing or no hearing decision to be made. But again, ORS agrees with the utilities that generally no evidentiary hearing is necessary in this case. And Mr. Chair, that is all I have to say, but thank you very much for your time.
Thank you, Mr. Torrey. Based on this, is there any further commissioner questions at this time? Hearing none?
Let me just ask you, since I gave you a heads up just in case.
Yes, sir.
I think you just said all that, but relative to the statute, that 584020, I think B through E, is it ORS's position that also just applies to NEM?
So, Commissioner, are we
In the statute 584020, I think the utilities of the opinion that I think B through E applies only to NEM, legacy NEM.
Mm-hmm.
And I think whatever comes after E, F through H or whatever, applies to solar choice. Is that ORS's view?
That is ORS's view, Commissioner, and I did my best to compare Act 236 with Act 62 late yesterday to figure out what 62 changed in 236, but and subject to check here, I believe that the revisit is a vestige from 236.
Thank you, Mr. Torrey. No more questions.
Thank you.
Thank you, Commissioner Caston. Any further commissioner questions? Is there anything further from any party? Okay. We are, as normal, going to step down and speak. I hope you'll all take a chance to meet the new commissioner. He's a good fellow, and look forward to having him here. We are adjourned.